Good afternoon. This is Drew Page with the law firm Randall Page, and welcome to Freedom Friday. Wasn't planning on doing a video today as it's Friday afternoon, just after 4:30, but I saw a news article pop up on my screen. Actually, someone texted me about it and got my attention, which I figured was probably coming anyway. But Wavy 10 reported today, the headline reads, Virginia Commissioner of Health says he'll mandate a COVID-19 vaccine. Bill could allow some to opt out. And so basically, Virginia Commissioner of Health, Dr. Norman Oliver, says that he plans to mandate coronavirus vaccinations for Virginians once it's made available to the public, which could take place as early as 2021, is what they're shooting for. And it says under current state law, only people with a medical exemption could refuse the mandate, which of course also means that there would be no religious exemption under current state law. However, it looks like they may be trying to make a religious exemption that could be put in there, but we'll see. So the question is that constitutional? Is that something that they can do? Can they mandate everyone in Virginia to have a vaccination? Or in any state? What's the state of the law in regard to vaccinations? Well, interestingly enough, there is a 105-year-old court case from the United States Supreme Court that addresses this very issue and has not yet been overturned. And that case is Jacobson versus Massachusetts. And I have that case in front of me here. In Jacobson versus Massachusetts, the issue was a minister in Massachusetts refused to get a vaccination. And the state had compelled vaccinations for the issue of smallpox. And the trial court found him guilty and ordered him to pay a fine. And he appealed that through the various courts, and it got all the way up to the Supreme Court. Now, here's how it came to its decision. It says, we come then to inquire whether any right given or secured by the Constitution is invaded by the state as interpreted by the state court. The defendant, which was the pastor in this case, insists that his liberty is invaded when the state subjects him to fine or imprisonment for neglecting or refusing to submit to vaccination. So in other words, the minister was saying that the state's invading his privacy rights by mandating this smallpox vaccination. But the Supreme Court says that the execution of such a law against one who objects to vaccination, no matter for what reason, is nothing short as an assault upon his person, is what the defendant said. But the liberty secured by the Constitution of the United States to every person within its jurisdiction does not import an absolute right in each person to be at all times and in all circumstances wholly freed from restraint. So what does that mean? That means even though you may have a right to your body, it is not an unlimited right according to the U.S. Supreme Court. There are restrictions that can be placed on your body. And so there are manifold restraints to which every person is necessarily subject for the common good. So you can already see where this is heading. In this Jacobson case is looking at the bigger picture, looking at the whole village. Yes, you have rights to your body, but it's limited by the common good. What's for the common good? On any other basis, organized society could not exist with safety to its members. Society based on the rule that each one is a law unto himself would soon be confronted with disorder and anarchy. So we see here in Jacobson versus Massachusetts, the Supreme Court is basically saying we do not have an absolute right to our own body. And so we could be subject to vaccination. It goes on and says Massachusetts required the inhabitants of a city or town to be vaccinated only when, in the opinion of the Board of Health, which is kind of like the Board of Commissioner today, that was necessary for the public health or the public safety. The authority to determine for all what ought to be done in such an emergency must have been lodged somewhere or in somebody, and surely it was appropriate for the legislature to refer that question in the first instance to a board of health composed of persons residing in the locality affected. So what is that saying? That's saying that a legislature can delegate this authority to determine what's best for as far as vaccinations to a agency like the Board of Commissioners, of Health Commissioners, or a Board of Health, which is exactly what's being done here. That's being given to the Virginia Health Commission. It says there is a sphere within which the individual may assert the supremacy of his own will and rightfully dispute the authority of any human government, especially any free government existing under a written constitution, to interfere with the exercise of that will. But it is equally true that in every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under the pressure of great dangers, be subjected to such restraint to be enforced by reasonable regulations as the safety of the general public may demand. So the Supreme Court is noting that there is a power that comes with the body, okay, but that is not unlimited, and that the validity of the good, of the common good, may outweigh the validity of the individual. So what do they do when there's issues about debate? So, for example, there was some evidence that the minister presented saying, well, there's medical authority saying that the vaccine actually doesn't do what the government is saying that it does, that it doesn't actually work. So there was some debate within the medical community. Kind of like we have debate today about whether about certain aspects of the COVID mask mandates and it's soon coming apparently vaccine mandates. When there's disputes between the medical community, how are they resolved? Well, the Supreme Court leaves that in the hands of the legislature. It says we must assume that when the statute in question was passed, the legislature of Massachusetts was not unaware of these opposing theories and was compelled of necessity to choose between them. It was not compelled to commit a matter involving the public health and safety to the final decision of a court or a jury. So in other words, when it comes to these matters of public health, the Supreme Court is not going to take it upon themselves to decide what the legislature wants to do. They are putting it on the elected officials to determine what is best for the common good. Now, it goes on to say that the minister then brought other evidence to suggest that the vaccine was actually hurting people. So it says the defendant offered to prove the vaccination quite often caused serious and permanent injury to the health of the person vaccinated, and that the operation occasionally resulted in death, and that it was impossible to tell in any particular case what the results of the vaccine would be or whether it would injure the health or result in death. So again, this issue is something that's been debated on social media as well. If they require a COVID vaccine, is it going to do more harm than good? That's something that was raised in the Supreme Court case. How did the Supreme Court deal with it? They again punted to the elected officials. These offers, in effect, invited the court and jury to go over the whole ground gone over by the legislature when it enacted the statute. So even when there may be some question about the validity of it and whether it can cause harm, they're leaving that to the elected officials to make that determination. Now, I was debating with one of my law school buddies on Facebook who said, well, Jacobson versus Massachusetts doesn't give the state unlimited power in regard to vaccinations, and that a COVID vaccine that didn't give any exceptions would be unconstitutional. And I tried to explain that that is not the case. That is not the law in the land, in federal or state for that matter, but particularly as relates to the Jacobson case. And I can prove it. And I can prove it through the way that other courts have treated it. There was a case called Zucht versus King, and that was a Supreme Court, an appeal to the Supreme Court of the United States, where they sought certiorari, which is where they're asking the court to grant them an opportunity to argue their case. And in that case, it was a San Antonio, Texas ordinance that required vaccinations in order for students to attend school. they argued that it violated their free exercise of religion, and they argued that it violated their fundamental right to privacy under the 14th Amendment. In a very short opinion denying them from even hearing the case to the U.S. Supreme Court, it says, long before this suit was instituted, Jacobson versus Massachusetts had settled that it is within the police power of a state to provide for compulsory vaccination. That case and others had also settled that a state may, consistently with the federal Constitution, delegate to a municipality authority to determine under what conditions health regulations shall become operative. And still others had settled that the municipality may vest in its officials broad discretion in matters affecting the application and enforcement of a health law. So this one little denial of certiorari basically says that if the legislature, as delegated to the Board of Commissioners, says that a COVID vaccine is mandated, then it's constitutional. We can try to argue it, we can fight it or whatever, but the courts are going to punt back to the legislature. So what's the remedy? Well, we'll deal with that in a second. I still want to make sure that law school friend of mine knows what the law is on this, because I think it's important. So the next level down from the Supreme Court are the Federal Circuit Court of Appeals. And in the Second Circuit, in Phillips versus New York, there was another public health vaccination that was ordered in New York, which of course is a hotbed for COVID. So when the plaintiffs complained and asked for an injunction against having to get this mandatory vaccine for their schools, how did the Second Circuit Court of Appeals decide? You can probably guess. This argument is foreclosed. It's foreclosed, which means that we're not going to hear anything else about it. It's foreclosed by the Supreme Court's decision in Jacobson versus Commonwealth of Massachusetts. In that case, the plaintiff challenged Massachusetts' compulsory vaccination law under the 14th Amendment. The Supreme Court held that mandatory vaccination was within the state's police power. Plaintiffs argue that a growing body of scientific evidence demonstrates that vaccines cause more harm to society than good. But as Jacobson made clear, that is a determination for the legislature, not the individual objectors. Plaintiffs' substantive due process challenge to the mandatory vaccination regime is therefore no more compelling than Jacobson's was more than a century ago. You want to guess when this case was heard? 2015, just 5 years ago. Jacobson versus Massachusetts says that this question about vaccines is foreclosed. It is no longer a debate. That was the Second Circuit Court of Appeals in 2015. What about the Fourth Circuit Court of Appeals, which is where Virginia, North Carolina, West Virginia, and Tennessee are all under this federal law? So when we're talking about this Virginia mandate, how has the Fourth Circuit Court of Appeals ruled? Well, in an unpublished opinion called Workman versus Mingo County Board of Education from 2011, which was just 9 years ago, they, of course, upheld Jacobson versus Massachusetts. Says, in this appeal, Workman argues that Jacobson dealt only with the outbreak of an epidemic, and in any event should be overruled as it set forth an unconstitutional holding. Workman's attempt to confine Jacobson to its facts is unavailing. What does that mean? That means in this particular case, they were trying to say in this 2011 case that, well, it's not an epidemic. It's not a pandemic. It's not an emergency. This particular vaccine wasn't an emergency issue, and yet the state is still mandatory. So what is it that this circuit is telling us about this case? It says that it's unavailing. As noted by one district court, the Supreme Court did not limit its holding in Jacobson to diseases presenting a clear and present danger. Additionally, we reject Workman's request that we overrule Jacobson because we are bound by the precedents of our Supreme Court. Workman also argues that because West Virginia law requires vaccination against diseases that are not very prevalent, no compelling state interest can exist. On the contrary, the state's wish to prevent the spread of communicable diseases clearly constitutes a compelling interest. In sum, following the reasoning of Jacobson and Prince, we conclude that the West Virginia statute requiring vaccinations as a condition of admission to school does not unconstitutionally infringe workmen's right to free exercise of religion. So that's the Fourth Circuit, which includes Virginia right here. Jacobson is still good law. But what's the next step down? Let's just keep it going here. We're seeing a progress here. So you've got the U.S. Supreme Court, you have circuit courts, and then you have federal district courts. So how are they deciding this vaccination question? Well, in Hansel versus Arter, which is a United States District Court out of the Southern District of Ohio, they complained about an issue related to vaccinations in school. And they quote, you guessed it, Jacobson versus Massachusetts. Long before much of this attention to the right of privacy, a Massachusetts resident urged the Supreme Court to invalidate a compulsory vaccination statute on the grounds that the statute amounted to a deprivation of liberty and that it was hostile to the individual's own freedom to care for his or her own body. The challenge was rejected. A majority of the Supreme Court holding the Constitution's guarantee of liberty did not include an absolute right to individual freedom from restraint, and the collective interest in health and safety outweighed the petitioner's interest. And it goes on, actually, oddly enough, to quote Roe versus Wade, which relied on Jacobson to basically say that there's not an unlimited right to your body, but there are certain ways that even in abortion, some rights can be limited. So they go on to say, this court believes that this passage in Roe v. Wade to signal the inconsistency of plaintiffs' positions, that the immunization decision is entitled to the same protections, yet it does not necessarily follow that the bodily autonomy per se has been deemed fundamental. However conceptualized, given the Supreme Court's view of the immunization decision, its view of the lack of congruence between bodily autonomy and privacy, and our mandate to give a fairly restrictive reading to these aspects, this court concludes that the immunization decision is not encompassed by the right to privacy. Plaintiffs contend, on the other hand, that Jacobson is no longer relevant. Now, why would they argue that? Well, probably because the case is 105 years old. Of course, at this time, this case was 1985, so it wasn't quite that old. But basically, they say, nope, Jacobson versus Massachusetts is good law, and it gives basically the state an unlimited right for vaccinations. Whitlow versus California in the Southern District of California in 2016. In this case, now this is one that's really going to strike home. In this case, California originally had a personal belief exemption, which basically meant that if you had a personal belief, whether it was religious or whatever, you did not have to get the mandatory vaccination if you can express that personal belief. Well, California eliminated that so that even there was not even a religious right to be able to get a vaccination. And so they asked for an injunction against the state enforcing that. How did this federal district court resolve the matter? It says, for more than 100 years, the United States Supreme Court has upheld the right of the states to enact and enforce laws requiring citizens to be vaccinated. They cite the Phillips case that I cited to you from the Second Circuit Court of Appeals, and they also cited the Workman case, which I also cited as well. And they go on to say, it is clear the Constitution does not require the provision of a religious exemption to vaccination requirements, much less a PBE. So even if they don't include a religious exemption, it doesn't matter. It's up to the legislature and the Board of Commission about whether or not to make a mandatory vaccination. So what does that mean for us? That means that if our elected officials decide to mandate this, we're screwed. We have to get it, or we face penalties and jail and other things. So how can we stop it? How can you stop the mandatory vaccine? Well, you heard the court tell you, and they told you multiple times. It's up to the legislature. It's up to your elected officials. So what does this mean? It means elections matter. Elections matter. who you vote in the office. We have our elections for governor and certain assembly members and so forth coming up. Be cautious with who you vote for. You might have voted for a particular party your whole life, but now you're realizing, hey, I might have to get this mandatory vaccine that has been rushed through and nobody knows anything about. The only way you're going to stop it is by electing officials that will stop it. So this election may be one of the most important elections in Virginia history. So be cautious with who you elect. Unless, of course, you want a mandatory COVID-19 vaccine that has not been vetted appropriately and hasn't been, given enough time. Elections are the key. And if you don't pay attention to what the elected officials are saying, you'll be lined up with the rest of them getting the needle in your arm. So make sure that you vote on this issue, because elections are the only thing that'll stop a mandatory vaccination law. Period. End of story. That's the law of the land. That's the law of the federal Constitution. And that's how it's going to be. And there's not really any debate. So I'm sorry for those who misread the law and think that Jacobson allows some wiggle room for us to debate. There is no debate. The debate's foreclosed. It's done. The only way that we can stop the COVID vaccine is through elections. So make sure you vote right. Feel free to check out our website at www.randallpagelaw.com. And please like our Facebook page. Please share this video, because we need to make sure everyone knows that this is a voting issue. This is an election issue. And if they don't vote appropriately, we're going to find ourselves all standing in a line waiting to get a needle in our arm. All right, God bless. Have a good weekend. Please share this video, like it, comment below, and we'll keep you posted on things as they develop.